Hello, everybody. Good evening. Coming in a little bit late tonight, but here nevertheless. Hello, everybody. Welcome on in. Good to see you all. I'm in a little different place today, so you'll have to make sure and let me know if everything is working okay. So I had to move locations, but hopefully this will work out. Hello, everybody. Hi. Yes, had to start a little bit later tonight, so I'm so glad you all could join me. Good to see you. Welcome. Hopefully everyone's week's been going okay. It's been busy. It's been a busy week. It was a busy day. Oh my goodness.
Find that on your calendar.
Alexa, shush. Good evening. Hello. Oh, good. Yes. Oh, yes. Need to move the camera up a little bit? Yes, I will move it up. I will probably go into the Georgia indictment first. I wanted to give kind of a review of what's going on here, but then, yes, so I made sure that I set the camera up this way so I can pull it way up so we can see the slides. So, hello, welcome. Yes. Well, it's good to see you. It's good to see all of you. Love to see it. So, yes, I had planned to go at 8, but I was lucky to be able to finish up my work so I could come on a little bit sooner. So, hello. Oh, thank you. Thank you so much, Superstar. I appreciate that. Yes, Brian, there's so much going on. There's just so much going on. Hello from Michigan. Well, hello. Good to see you. Oh, thank you. Yes. Just, something a little fun. Oh, hello from Scotland. Well, hello. Brad, did I cover Epstein? No, I did not. There are just a lot of trigger words, so I haven't really got into those cases. I've been kind of looking to try to figure out how to do it in a way that wouldn't trigger anybody, so we'll have to see. I'm just getting started. Yep. Nope, I'm just starting, Suze. You're just right on time. Oh, from Delaware. Hello. Yes, I think it's important. I'm just trying to figure out how to do it in a way that works out. So, well, welcome everybody. Welcome. Yes, my ring's in a little different lighting tonight. Oh, thank you. Thank you so much. So, yes, doing very well. It's been a busy day, but that's all right. We're going to get diving right in. So, just for today, Vicki, I only changed for today. I had a few things I had to take care of, so I couldn't come at my normal time tonight, but I needed to come on a little bit later, but should be okay now. So, yep, got the bling on tonight. So, quick update. Oh, thank you, Vicki. Thank you. So, quick update, everybody, just so you know, out of the Georgia case, we had Sidney Powell had a hearing on her motion to dismiss, right? So Sidney Powell is set for trial with Mr. Cheesebro on the 23rd. Her attorney had filed a motion to dismiss and asked for a hearing today. So they did have a hearing. The motion was denied. He was arguing some questions about exculpatory evidence. It didn't really go over well. The judge wasn't particularly impressed. So I thought that was it was interesting to watch how the judge was like, look, this is Georgia. So I thought it was pretty good. Anyway, yep, cheese and crackers. So they are set to go still. So everything is set for Georgia, but did want to do a quick update on that. So for the other updates, before I dive into the New York case, we do have a motion to dismiss that was filed out of DC, and it was on presidential immunity grounds. So I will go through that, not tonight, but I will be going through that at some point. That was really interesting. But a couple of discovery hearings today and tomorrow. That'll be going on. Oh, thank you. Oh, that's so cute. So that's been going on. Florida, we don't have anything new that's been filed other than this kind of moving it, this continuance question. We've got the Garcia hearing next week, so that's pretty much all caught up. The gag order in DC's hearing is on the 16th. New York criminal motion to dismiss, their response is due on the 10th. So next week will also be pretty busy, everybody. So it'll be a busy, busy time. Yes, I saw that. Trump had told the judge that he would be in New York. That's why they couldn't do Cohen's deposition. Exactly. So that was very interesting, I thought. Very interesting. So I guess he did have to show up, I guess. But yes, he is scheduled for this weekend. So I believe he will be either Saturday or Sunday. He is set to go in for his deposition. So we will see how that all turns out. So yep, they're coming in. The mods are coming in. I've got some now, so we should be okay to go. Kind of a weird night tonight. I'm starting a little bit later than usual. I just had a couple of things I had to take care of. So we should be okay. But for tonight, everybody, I had wanted to take you through the state's opening arguments. All right, so I was able to pull the state's PowerPoint presentation that they did, and I thought I would take you through. I think it's a pretty amazing presentation. Now, Tuesday, we went through the defense's presentation for their opening statements, and, it was kind of lukewarm, but their presentation is really good. The state's 2 a.m. in Ireland. Oh, well, hello. Yes, sorry, I'm coming in a little bit late tonight, but we should be good to go. We're gonna just kind of buzz through it. Voluntarily dismisses a case against Michael Cohen. Yeah, there were several things. Michael Cohen's been involved in a lot of different cases, so we'll have to see how all of those things turn out at this point. Why is he not in jail yet? It's a good question. It's a good question. They're definitely giving him a lot of wiggle room for sure. So, like a lot more than most defendants would get. But let me go ahead and start diving in. Before I get too far, though, I did want to say, let us not forget that the judge has already ruled regarding the first cause of action. So he's already ruled on that motion for summary judgment. So the rest are just counts 2 through 7, talking about intent and materiality. So we want to keep that in mind as we go here. We've also got, there's a lot of craziness going on. Now, I have printed out, just for my own assistance, this is the New York docket of all of the different exhibits and everything that's been filed on this entire case. So I do have this, and I think it's really helpful. We're not going to have something like this in our criminal cases, so it's really interesting to be able to have it for our civil case to kind of look at the different documents. So I think it's super helpful. But Trump did just file a motion for a stay, and that just means he's asking the judge to pause everything while he appeals it. So I don't know if the judge is going to grant that or not, because they've appealed everything, and everything will continue to go on being appealed. But we will see what happens. That was just filed, but so far the judge is ready to go. When we will find out what foreign entities have. Oh, I have no idea when that will be. I have no idea. Yep, no idea. There's a lot going on. I know a report just came out that there was confidential information about military submarines that has been disclosed, but the details of that are still coming out, so I don't have those documents yet. But Yep, a lot of interesting information, especially with those classified documents. So, yeah, Steffi, I agree. I agree. It's a lot. It's a lot. All right, well, let's dive on in. Again, I'm in just a little bit different location tonight, but it should work out a little bit better. Hopefully, everyone can see the slides okay, and I'll go ahead and yes, he did file a motion to dismiss for the DC case, but on grounds of presidential immunity. But, I think they just have to file those motions. It's not really, the US v. Nixon already set out that immunity doesn't extend that far, and that's been supported by the US Supreme Court. So he's just filed it, but that makes sense. Yeah, I think the banks are waiting. The banks are waiting. Yeah, yep. All right, so let me go ahead and get started here just to kind of get us going here. So I'm going to write down my sticky note here. This is the New York civil case. And this is the government's opening statements. Now, I think they did an exceptional job setting out the law, setting out all of the different elements that need to be proven and so on. So I think they did a good job. As we go through this, I think a lot of the questions that we've all had will be answered pretty well. Just writing my sticky note out here, opening statement. So this was filed as an exhibit with the court. So just so everyone knows. Yeah, he would fill in as Speaker of the House, but, they still have to have a certain number of votes in order for that to happen. So, I'm not sure. And they also have some requirements when it comes to indictments too. So I don't know how that would go. All right. Yes. Sorry about that. I'm starting late today. Okay, so we're starting again. This is the government's opening statements and their PowerPoint presentation. So we have just this opening slide here where they're talking about years 2011 all the way to 2021, and they're going to take us through each of these different years and where the fraud was, which documents had the different pieces of fraud that they're talking about. And a lot of the evidence is set out in this presentation, so I think it's super helpful to understand how things have been going about. So again, we've got the motion for summary judgment that was granted on that first cause, so that's already been decided. Now we're just trying to determine the last causes. So here's their overview here. And their first slide, they're going into what's illegal, the injunctive relief, which is the dissolving of the different licenses, and then disgorgement. Now, we'll get in further into what disgorgement is, but disgorgement means the losses that people had because of the bad information that was in these reports. So they will kind of go into that as well. But I'm taking you slide by slide here through their entire presentation. So it goes pretty quick though. So here's what's left. We've got count 2, falsifying business records. Count 3 is conspiracy. Count 4, issuing false financial statements. 5 is conspiracy for that. Count 6 is insurance fraud, and count 7 is conspiracy to commit insurance fraud. So these are the last counts that are left. So they've done a really good job, I think, with the visuals on this too. So we've got, I think this next chart is super helpful. What they did in this chart was they set up all of the years from 2011 to 2021. They wrote out in blue what the actual prices were, what the actual amount was, and then the amount that was actually written on the statements. So this visualization is so helpful to show how much it was inflated by the red marks every single time. They highlighted 2014, which they see as the year that it was inflated the most. But each one of these red bars goes to how much he had inflated the actual amount. So this is what was the actual amount that it was true according to the standards used in the industry. And this is what he put on his financial statements. Yeah, it's quite a bit. When you look at it just in a chart like this, it's pretty significant. So that's their opening piece. Now they're going to go into each individual defendants and which roles they played. Now I like how they set this up, although it is a bit like a RICO case. Most people realize or recognize that RICO cases kind of set out like spokes on a wheel, but that's how they've sent these defendants out as well. Whoops, I missed a question. Sorry about that. Listen to the opening statements, then asked for a stay. Yes, a whole bunch of stuff has already happened. And then they asked for a stay. They weren't ready yet to file their appeal, I guess. So now it's just been done. The appeal is now on the record. So, yes, can you explain the differences between falsifying and conspiracy to falsify? Sure. So the actual falsifying itself is one code section. Conspiracy is the agreement to falsify. So the actual crime or the actual offense, again, is falsifying, but conspiracy is that agreement. So for each one of these three different causes, there was a conspiracy between all of these people to do the harm that was done. So that's why they're two separate counts. So we'll get into that a little bit more as we go through this. So we've got Trump here at the center, and this again looks very much like a RICO presentation, but it's not a RICO case. We've got Donald Trump Jr., Alan Weisselberg, Eric Trump, and down here is Jeffrey McConney. So the first one that she sets out is Donald Trump, the involvement in fraud for 2011, 12, 13, 14, and 15. And here's the basis for the presentation here. Such valuation methods include but are not limited to the use of appraisals, capitalization of anticipated earnings, recent sales and offers, and estimates of current values as determined by Mr. Trump in conjunction with his associates and in some instances outside professionals. So she's kind of setting us up here. Here's the next set of involvement, real and operating properties. So first we're going to talk about Trump Tower. Estimated current value, $707 million. It's based on an evaluation by Mr. Trump in conjunction with his associates, outside professionals. Applying a capitalization rate to the cash flow to be derived from the building's operations. So again, she's just laying this basis down. Now we've got 40 Wall Street here. Let me just make sure I've got my slides in the right order. Hopefully they're in the right order. Estimated at $550 million, based again on successful renegotiation of the ground lease and evaluation made by Mr. Trump. So she's just kind of setting this up again for us. So now she's going to look at individuals. We've got Donald Trump Jr. and Alan Weisselberg. So when we're talking about Trump Jr. and Weisselberg and their involvement in the fraud, we've got years 2016, 17, 18, 19, 20, right? So this was an important year. The basis for the presentation for their charges were assets are stated at their estimated current values, liabilities at their estimated current amounts using various valuation methods. Such valuation methods include but are not limited to the use of appraisals, capitalization of anticipated earnings, recent sale and offers, and estimates of current values as determined by the new trustees of the Donald J. Trump Revocable Trust dated April 2nd of 2014. As amended, the trustees in conjunction with associates and so on. So considerable judgments necessary to interpret market data, develop the related estimates of current value. Accordingly, the estimates presented herein are incorrect. So we move on to this next page with Trump Tower as well. So estimated current value, $631 million again. So she's setting us up here. 40 Wall Street, we've got $796 million based on those evaluations made by the trustees. So we're setting the groundwork here for having our numbers not be quite matching up correctly. Next, we've got Eric Trump on here. For him, she's specifically pulling in evidence of a phone call conversation that was done June 30th regarding the Seven Springs property. So she pulled in this record. Hopefully you can see this here where we've got the selling price, the profit, and she's comparing numbers here and the value. So again, just kind of setting up the disparaging or the disparate numbers here between the two sets of values. Also, we've got two more phone calls involved, 2013, 2014. So she's showing the evidence that's saying that there was knowledge that these numbers were incorrect through these phone calls. So now the point again for an opening statement is to just walk the fact finder through what your presentation of evidence is going to be. So she's giving the judge a roadmap on what she's going to be calling people in to testify about. So that's really the point here. Did somebody just ask about Ivanka? By the way, I do have, after I'm done with this presentation, I do have the motion regarding Ivanka being pulled from the case. So I wanted to go through that as well. So we will talk about that. Right. She was left out because she wasn't part of the tolling or the tolling agreement that was made between the Trump organization. She was not employed with the Trump organization on the date that the tolling agreement was made. So she wasn't included. So her statute of limitations ran. But I will be going into the motion and opposition to the motion regarding that. Yep, you bet. All right, so we have covenants here, guarantor. Now, I think this is really helpful because she's pulled in actual information explaining where there were problems. She's saying here, one of the agreements was that they shall maintain a minimum net worth of $3.0 billion, excluding any value related to the guarantor's brand value. All right, notice this brand value that he's talked about. Well, one of the agreements with one of the companies was that we had this $3 billion net worth. So that covenant was broken because these numbers were incorrect. So we've got another one from Ivanka sent to Ellen, Jason, and David. And we've got a line here. It doesn't get better than this. Let's discuss ASAP. I want to call Rosemary and thank her. But if there are any asks, I would like to give her an indication. I'm tempted not to negotiate this though. So again, she's talking about trying to get favorable terms through the financial institution here by kind of fudging these numbers. Now, Donald Trump personally used his own financial forms to try to secure loans. And she's got evidence of a letter here, November 15th of 2011. And as per our conversation, I'm pleased to enclose the recently completed financial statement of Donald J. Trump. Hopefully you will be impressed. I'm also enclosing a letter that establishes my brand value, which is not included in my net worth statement. And then here's the signature. So again, she's just got all of this evidence and she's putting it right in front of the judge. Again, when it comes to the information he had filled out on the forms, it was inflated by a lot. Yes, without the brand value. So defendants moved numbers between December of 2015 and March of 2016. So Seven Springs was at $291 million, but it was actually around 56 for appraisal. Appraisal no longer separately valued, combined with a triplex concealed in other assets in the SFC. You can see here also the triplex actually at $200 million, but it was bumped up to 327. Here it was 660 million, bumped up again to 735 million. I mean, again, that's pretty significant inflation of those kinds of numbers. So when in fact, Doug Larson's valuation was $195 million less. So here's 40 Wall Street, and they're setting up the appraisal value. The conclusion of that appraisal was $540 million, according to the June 1st appraisal. Now she's got the appraisal pulled into this slide. She also has the assessment here, or the yes, the rest of the assessment that was done, the statement of financial conditions set out right here. So she's got all the evidence on the slide right there. I think it's pretty helpful. All right, next we've got Douglas Larson again, never retained by the defendants. Defendants claim their value supported by Doug Larson. So she's setting up, questioning the credibility of this particular witness that they're going to pull. 2015, based on the information provided by Douglas Larson of Cushman and Wakefield, which reflects a rate cap of 3.04 for 100 Wall Street. Based on a telephone conversation with Doug Larson on February 1st, since the ground lease still has about 190 years left, the effect in the cap rate is minimal. To be conservative, we increase the cap rate 0.25. Again, this is a direct quote from this financial document here. Defendants increased the value of 40 Wall Street even more to $735 million. $195 million over the actual appraisal amount. You know, again, we're not just kind of rounding up here. This is, $200 million is pretty significant here. So this is for 40 Wall Street. She's got her, the markup that was listed in this document. That's one of the pieces of evidence. And then this is the financial disclosures form right here. So on the left-hand side of all of these forms are the forms where they put the false information in. Oh, thank you. Thank you for that. All right, next, this markup was based on false claims that the appraisal did not include a new lessee. So again, we've got the appraisal as well here, just facts. These are just all documents where the numbers aren't matching up. So she's continuing on. I'm kind of flipping through these quick, but I don't know that we need to spend too much time on them. Dean and DeLuca was already accounted for in the appraisal. So this had already been taken care of for 40 Wall Street. Income vacant retail space here was already set out. So that inclusion was improper as well. And here we've got a draft of a supporting data spreadsheet. Some of the exhibits in this file have been sealed, so they are not available to the public, but a lot of this information on all of these slides is all available. Defendants also mark up 40 Wall Street to $660 million, even though it was appraised for $540 million. So again, these numbers are just such a huge discrepancy in the numbers. Don't the banks do their own appraisal? They do, but they also, anytime you put your financial information down on your forms, it's supposed to be truthful. That's part of the requirements when you fill out a form like this. Now, they will do their due diligence, but they also are relying on good faith that you're filling out the forms properly, because it is actually incorrect or bad to put false information on financial documents. Yeah, it's huge. It's huge. And again, it's not like, if they're appraised at 540, maybe we just bump it up to 600. Let's just round it off. No, it's $660 million. So the fact that it was bumped so high also shows the intent to fabricate the numbers. So that's one of the elements that they're looking for when trying to prove fraud, was that they knew that the numbers were inflated, and they even went so far, well above what the actual appraised value was, to show that that was their intent. All right, so defendants moved numbers between December 2015 and March of 2016. Again, Seven Springs here, 56 to 291, 200 to 327. And then 40 Wall Street has a value, they had valued it at $660 million, which again was quite a bit over the appraised value. All right, next, defendants inflated the triplex to $327 million from $200 million. Again, $127 million inflation is pretty significant in this particular situation. We've got the supporting spreadsheet. She's included here. So we've got both of them included, just showing how these numbers are incorrect. Here's what it was actually at, and then here's what was put down on their forms. Again, a huge inflation, which is showing this intent to defraud in that particular situation. All right, defendants moved numbers between December 15th and March 2016. So Seven Springs, we've got 56 to 291, but the triplex was inflated to 200 million, and then Wall Street we have here at 660 million. Next, the value of Seven Springs isn't mentioned in the finance paperwork that was filled out. So valued at $291 million based on an assessment made by Mr. Trump in conjunction with his associates. So let's take a look and see what the final numbers were that came out of that situation. Supporting data shows Seven Springs listed among other assets. So Seven Springs wasn't even specifically listed in their financial statements. Okay. Who did someone say who's the victim? You know, this is white collar crime, right? I mean, you know that that's what this is. So even if you pay back all the loans, it doesn't mean you didn't commit a crime. The crime was to put fraudulent information on financial documents. That's a crime. I mean, that's something you can be sued for. So who got hurt and how they got hurt is irrelevant. The point was what you did, right? So you're the one that committed the offense. It's not on the victims to show that they were harmed. It's on the state to show that you did something wrong. That's how the rules work. So supporting data showing here, again, other assets rather than set out in its own piece. Now, this is a copy of an actual showing of a marked up letter that had been sent. I always think this is really interesting whenever you can get a witness's actual writing on something like this. So you can see how these numbers have been crossed out and changed. I mean, that's pretty damaging information. Yes, that is exactly what fraud is. You are correct. That is what fraud is. Writing wrong information down and saying that it's true. Next, we've got Trump's old post office. Again, we've got another form that's been marked up. This has been crossed out. The numbers have been changed. This was March 11th of 2016. Seven Springs value dropped over $200 million to $56.5 million after Trump gave up development rights. So that's a pretty significant drop. And they're illustrating that again with receipts showing that drop in value. It's pretty obvious, absolutely. It really is. I mean, they're not really hiding anything here. There's no hiding. Everything is just all out in the open here. Seven Springs was valued at $291 million. Again, this is a markup done in 2015. We've got, instead of 5.2%, we've got 4% just written in. Which matures on July 1st of 2019. So again, you can see this is where the intent is coming in. Right. I mean, Michael, who do you think the victim is for white collar crime? Right? Oh, look at the galaxy. Oh, thank you. Thank you so much. Right? I mean, we have crime and we have offenses and we have lawsuits, but we have that for particular reasons, right? We don't ask our victims to prove that they were harmed. We have laws. If you break the law, then you can have to face the consequences. That's what's happened here. Mr. McConney's markup as well. So we've got this hand written out again and a picture of the witness who will be coming in to testify December 29th as well. So again, we've got all of our numbers. Now you can see, look at this. Look at this on this document. Here's the actual written out numbers typed out. And then next to it is a handwritten column of number changes, every single one of them. So Trump Tower was at $707 million and it was moved to $879 million. I mean, you can actually see where they wrote in different numbers. I mean, that's pretty obvious, right? Right, so here we go. And then Mr. McConney sends a markup to Mazars before sharing it with Mr. Wesselberg. So we're showing this, who had the numbers, who marked up the numbers, how they were placed in there. This one was marked up on June 30th of 2014. So before Alan's comments, should be talking to him tomorrow morning. What was that name? Mr. McConney? Right, the state of New York is the plaintiff because it was the state of New York laws that were violated. The state of New York said you can't put this level of fraudulent information on your financial forms. You just can't do it. It's, it's a law. That's people who were elected wrote the law. Exactly. Yep, New York. So, defendants moved numbers between December 2015 to March of 2016. Seven Springs at 291, Triplex 200, and then 40 Wall Street. Now, again, the Seven Springs number is huge. Such a huge difference from that original 57 million. That's just an enormous difference. All right, so we'll move on. Or 56. Sorry, I think I said 57. So again, she's showing these numbers over and over and over again. See, she's being repetitious, which is extremely helpful when you're doing a presentation like this. Yes, I have seen the motion that he filed for presidential immunity in DC. Yep, and I will be going over that, not tonight though, but I will be setting that up and talking about that. So Seven Springs again, and then the disparaging, or the disparate, disparament. Oh, the numbers don't work. How's that? So next we've got Patrick Burney, Assistant VP Financial Operations at the Trump Organization. Donald likes to see it go up. Here's the question. And is it correct that Mr. Wesselberg informed you in substance that Donald likes the numbers to increase at some point between when Mr. Trump became president in 2017 and the onset of the COVID pandemic in March of 2020? To be clear, I don't think two things. Alan Wesselberg told me Donald likes to see it go up in that period that you just said. Not Donald told him and then told me in that, like when he was president. Okay, Alan told me that. So Mr. Wesselberg told you? Yes, that Mr. Trump likes it to go up. He likes it to go up. And it, I don't think, refers to assets. I think it refers to net worth. That, again, is pretty damaging. Of course, he'll be called in by the state to testify. Now, I had tried to pull up these clips so I could show everybody, but it just wasn't possible for me. At some point, though, I'm hoping to get the transcripts fleshed out, but we do have this deposition by Michael Cohen, and this was taken in April, late April, where he talked about this process of including the numbers, making them bigger or lower, depending on what's going on. So, and then also talking about the years that were involved. He is set as one of the state's witnesses as well. So this is the Forbes article that Mr. Cohen is referring to in his testimony. He was saying that Trump had expected him to make the numbers match what Trump had said, as opposed to what they actually were, because there was a Forbes article coming out. So I'm summarizing again his deposition for you. There's girl math, boy math, and Trump math. It's so true. It's true. Yes, it's very unique math. It's unusual. So here's the Forbes article again that was claiming his numbers at a certain level that they actually were not, and that's supporting Michael Cohen in order to kind of give credibility to what he was testifying to in his deposition. Trump University math, yes. Oh, goodness. All right, so we've got March 10th of 2017. We've made available to you all financial records and related data and any additional information you requested from us for the purpose of the compilation. We have not knowingly withheld from you any financial records or related data that in our judgment would be relevant to your compilation. So again, this was included in his statement of financial condition. He's saying, I'm giving you all of the information that it's true and accurate. And of course, it was not. So that is, fraud. That's kind of what the problem is here. It's against the law to put fraudulent information on financial documents. Yes, it is. For all of us. Nobody can do this. It doesn't matter who you are. You can't do it. It's not allowed. It's not allowed. So we've got March 6th of 2017 as well here. Another letter here. I spoke with Alan. We're going to leave those alone. Again, showing that the numbers were so liquid that they moved them up and down as needed. Here we have October 11th of 1994, and this is showing the square footage. I think we've all heard now that there's been this big question that his actual square footage was 10,996, and he had claimed it at 30,000 in order to get the benefits from having that. So that was pretty significant. Now you might say, why do we have a document from 1994? Again, it's because it's got that original square footage in there that has his signature on it. So he's acknowledging that original square footage. Yep, you got it. So here again, the Trump Tower penthouse, he has written down March 3rd of 2017 that his penthouse occupies 33,000 square foot. Such a huge difference in and of itself. Maybe they could say, oh, we just made a mistake. But because it's taken with all of these other numbers that have been inflated, that's where the intent comes in to show that the intent was to be fraudulent. So that's pretty significant again. Now we've got the insurance element. Remember, insurance fraud is one of the final charges here. So Alan Weisselberg lied to the insurance underwriter. Fair value of the properties is appraised annually by a professional firm. This year it was done by the Newmark Group, previously done by Cushman and Wakefield. The reason for the change is the individual at Cushman and Wakefield with whom the organization had a long-standing relationship moved to Newmark. So again, we've got a document here showing that the information is incorrect that he's presenting to the insurance company. Now we've got a clip here, which I am not able to show you in this format, but this is the deposition that Mr. Trump did in April. Now, some of you may have joined me on a live before when I read through part of his deposition where he talked about these numbers, the square footage, how he crunched his numbers and so on. Oh my goodness. So yes, jump scare, sorry. Sorry. Biani. So yes, his deposition here, but I did go through the piece that they've actually had as well. So just explaining again how he thought that the numbers were okay, and this was how you did the math, but you don't do the math like that. So yes, the worthless clause. Oh, it's a lot. All right. Next, we have Alan Weisselberg, one of the named defendants, and he's denying all responsibility. If I said the phrase GAAP, are you familiar with that, which is the generally accepted accounting principles that's used in the industry? And he's like, they're just suggestions. And the attorney's like, what? No, that's not how accounting works. So that deposition, very interesting. We also have Donald Trump Jr. denying responsibility. Earned your BS in economics from Wharton. Do you have any familiarity? And then they go on to ask, with the GAAP, or those general accepted accounting principles? And he said, I've heard of them, but I don't really know. He spent most of his time actually flirting with the attorney during this deposition, because she had asked him, can you explain what it means to you? And he said, I can't remember. It was so long ago. I'm like, okay, all right then. That's a new technique. I do the accounting stuff. Oh, yes. Oh my gosh. All right. So Donald Trump Jr., Alan Weisselberg, their involvement in the fraud. It started in 2016, 17, 18, 19, 20, 21. Trustees of the Donald J. Trump Revocable Trust, dated April 7th of 2014, was amended. Donald Trump are responsible for the accompanying statements and financial conditions. So again, she's linking everybody to the documents showing the numbers were inflated. Tell the IRS their suggestions. Yeah. How do you think the IRS is going to respond to that? Yikes. And can you imagine if it was any of us? I mean, we wouldn't even be talking. Like we would be, we would all already be in prison. There wouldn't even be a question. Oh, anyway, so we've got Eric Trump as well. Again, just asking about what he was responsible for. There were multiple phone calls he was involved in, along with emails, because he took over the business with Don Jr., of course, during 2016. So there's a lot of information that he had access to. So that was added in as well. Under the bus. Yes. To jail we would go, B. You got it. We would be. Oh, my goodness. Now, Alan Weisselberg. Now, as I've looked through all of this, Mr. Weisselberg really had, he was really at the center of all of this information. So here's his involvement in the fraud starting in 2011, going to 2021. We have the limited guarantor under this loan, all of these different loans as well. And then here's his signature. So he signed off on these numbers that were inflated. So there's no question that he knew what was going on. Now, up in this right-hand corner, she's setting out which loans were added. So let me just review that again. We've got the 40 Wall Street here. We've got Doral and the Chicago loans here involving Eric Trump. 2011, 2021. Again, this presents fairly in all material respects. So he's literally writing, these numbers are correct. Why is this civil? I think it's because that's how the Attorney General wanted to do it. I think she's familiar with this code section. I think she felt this was the best way to do it. The path of least resistance is usually what, any prosecutor chooses. So rather than try to take this down a criminal road, she wanted to take it down a road that was guaranteed. And honestly, I mean, like the judge just said, this is a documents case. There's really not much to prove. There's really not going to be much more to see in this trial because it's literally just all documents. And so if you just looked at the documents, you would see that the evidence is overwhelming, which is what the judge did and ruled on it without even having to go into all of the other evidence. So I think this is probably what, if I were to call any case open and shut, I would call this one open and shut. Yes, New York can have fines, but I think more importantly, no longer can they do business. I think that was really what her goal was, is what I'm guessing, because of how this section of the code is written. Now we've got Donald Trump Jr. with the Doral loan. Again, it's this acknowledgement. Everything is true that I'm telling you. Nothing in here is worthless. So maybe there is a disclaimer in there somewhere, but they're saying that everything here is true and accurate and signing their name to it. And that is the definition, again, of fraud. Started working on these cases ages ago. It takes time. Yes, it does. Absolutely. Very, very true. Next, we've got Donald Trump's involvement in fraud, 2011 to 2015. Again, these are all of the statements that were written with the bad numbers on them. Again, saying that this is presenting fairly in all material respects. So he's claiming all of these numbers are correct. He's not saying, why don't you go double check everything? No, he's saying these numbers are correct and signing it. And the numbers are not correct. So then this is the last page of her opening statement presentation here. We've got Eric Trump's involvement and your responsibilities. You have the following overall responsibilities that are fundamental to our undertaking the engagement in accordance with the SSARS. the design, implementation, maintenance, internal control relevant to the preparation and fair presentation of the financial schedules that are free from material misstatement, which is not true, whether due to fraud or error. The prevention and detection of fraud. So he is signing and stating that there is no fraud, there is no misstated information, and that is incorrect. So again, that's just oh, thank you, Kristen. Oh my goodness. So that's a pretty open and shut response there. So that is what we've got for the state's opening statements. All right, so her opening presentation. Now, I want to take you through, you give me a minute here. Oh, thank you, Callie. I appreciate that. Give me just a moment here and we will start digging in to the Ivanka situation, because I know a lot of people are wondering about that. We are wondering why Miss Ivanka was pulled out. So let me just, I've also got a motion in limine, so let me pull out the correct document here. One moment. All right, so let me see. I've got so many documents here. All right. All right, I will lower the camera here so we can get a little bit closer in. Just so you know, they do have, again, all of the assessments, all of the appraisals. All of this is part of the record. All of this is included as evidence. So, memorandum of law in opposition to Ivanka Trump's motion to dismiss. So she filed a motion to dismiss. Let me just move my chairs around here and then I'll go ahead and dive into this. That's pulled in correctly so we can see it. Pull this to the side. All right. JFK Jr. Oh, oh my goodness. Yes. All right, here we go. No, I'm not, we've kind of already talked about the international investors already because they're on the state's witness list. So I think we've pretty much got a good idea of who that's going to be. So, that's okay. Oh, yes, the IRS will get involved. Oh, yeah, they'll be getting involved. I have no doubt, but it's all about timing. I think this whole case is all about timing. No problem. All right, am I in frame, everybody, before I bump down to start talking about, am I in, out a bit of frame? Yes, in frame. Yes, okay. All right, so let's talk about Ivanka. I want to spend a little bit of time on this because it's a huge question. She wasn't pulled out of this case because she wasn't involved. She was pulled out because of the tolling agreement. Now, we've talked before about the tolling agreement. It was an agreement made between the Trump Organization and the prosecutor in the other case, that the Attorney General's office, and they said, we're not going to go forward in a suit as long as you agree to pause the statute of limitations. Everybody signed on, it was agreed to. At the time, can Ivanka be called as a witness for the state? Absolutely. She is on the list for the state. So, but at the time that the agreement was signed, she was not a part. Hold on, I'm pulling the agreement. I'm even at my big table today, everybody, and I'm still having to dig through my paperwork. Yikes! Yes, so, Ivanka is on the state's list, so she absolutely could be called in. Let me see here. Well, maybe it's in my other pile. I need to have my poor paralegal. I wouldn't dare ask for my paralegal's help at home for TikTok. That would not be okay. All right, well, you'll just have to, it'll show up in a minute, I'm sure. But there was an agreement between the AG's office and the Trump Organization to not file a lawsuit, and because of that, they paused the statute of limitations. So everybody who was involved in that, the statute of limitations were paused. I think probably the easiest way to show it. So let me just show it to you this way. We'll go a little backwards here. This was an exhibit created by Defense Counsel explaining, it was a visual aid for the statute of limitations discussion, okay? And this exhibit was AAF, and I'm not sure it's completely accurate, but this is defense's exhibit. And there was this tolling agreement. Defendants were bound by the tolling agreement for all claims from July 13th of 2014, and they're not bound, is what defense was arguing, up to February 6th of 2016. So there is this understanding that there was an agreement reached between the parties. Every single case has a statute of limitations. If you're outside the statute of limitations, you can't sue somebody. And in this case, what they did was they paused it. Everybody agreed to pause the statute of limitations, and because of that, they were able to bring the suit. But at the time that it was paused, Ivanka was not part of the company. So we'll get into more details as we go through her, the opposition to dismiss her from the case. Okay? So here we go. Ivanka had filed a motion to dismiss. Originally, she was named as one of the defendants. So this is the government's response. This is the AG's office response to Ivanka's motion to dismiss. So I'll just give you an overall view here. I'm not going to read it word for word, but we've got the table of contents, the argument. Number one, the allegations in the complaint establish that Ivanka Trump engaged in persistent fraud in violation of 6312, just like everyone else. Subsection A, Ivanka Trump actively participated in and had actual knowledge of the fraudulent scheme. She participated in the fraud, they explain that here, and that she had knowledge of the fraud explained here. Number two, allegations in the complaint establish that Ivanka Trump engaged in illegal activity in violation here. The AG does not assert any standalone cause of action for conspiracy. So what this means, so Ivanka is saying, hey, I wasn't involved in the tolling agreement. The AG is saying, but you were part of the conspiracy, very similar to the Georgia RICO situation, where it was this agreement to commit the problems that is the actual charge in place. And so she's saying all of them were part of this conspiracy, including Ivanka. So just because she wasn't involved in the actual offense itself doesn't mean she wasn't involved in the agreement. And that only kicked her out of the offense anyway because her statute of limitations had run. So she should be included in the conspiracy pieces. Next, the claims against Ivanka Trump are timely. The statute of limitations is 6 years plus 228 days because the complaint alleges a continuing wrong. The statute of limitations was equitably tolled until at least 2022. Now, this is something that we know on appeal. The court did dismiss Ivanka, but this is what the AG's office is arguing in order to keep her in the case. Ivanka and the other defendants concealed their fraud until February of 2019, and she goes into that here. And the AG is entitled to equitable relief if it proves its claims. So let's go through her different elements as well. Anything with her signature is approving, absolutely. And the AG is also saying too, it's ongoing. It's ongoing. But really the key to this case is this tolling agreement. That's really the key. And because she wasn't involved at that date and time, she was allowed out by the Court of Appeals. So let's get into that. But just because she was allowed out doesn't mean, she wasn't involved. It just means that her statute of limitations had run. Right. So a tolling agreement, okay, give me 1 second. I had printed it out so I could show everybody. So one moment, I'm going to find it. I'm determined. I'm going to swim through my paperwork and I'm going to find it. Oh my gosh. I know it's in here. Where did I put it? How about this? We'll do this jump scare. What? All right. Sorry. All right, here we go. Hold on. Motion to dismiss. Boy, for some reason, I cannot seem to find it. Boy, that is not very efficient of me. Let me try one more time here and see if I can find it. And if not, we'll just have to... Oh, shoot. Nope. Yeah, I can't find it. All right, let me summarize it. It's a contract that was made, the spooky stuff. Sorry. All right, there was a contract. All right, so the tolling agreement, here's the deal. 6 years in order to bring the suit, right? So from the very first date of the first alleged violation, all right, that's when the statute of limits starts to run. So you have 6 years from that very first date. So I think it was 2011. And so that would mean that if they were going to file, they had to file by 2017, right? To be within the statute of limitations. But what they did then around that time was the AG's office had filed a suit. And what they did was the Trump organization then, let me just make sure, I'm going to show you right here. The Trump organization had signed this agreement to pause the statute of limitations because they were about to run out of time. The statute of limitations was about to run. So in order to toll or to stop the running of the statute of limitations, they had to have this agreement, or else they wouldn't have been able to bring a suit at all. So that's what the tolling agreement is. It means it tolls or it stops the statute of limitations from running, so they do not run out of time to file the case. So finding the claims are timely against defendants subject to the tolling agreement if they accrued after July 13th of 2014, timely against defendants not subject to the tolling agreement if they accrued after February 6th of 2016, then dismissing the complaint against Ivanka on statute of limitations grounds, finding she was not an employee of the Trump organization at the time which the parties entered into the tolling agreement. All right, so a tolling agreement is a contract to stop the statute of limitations. So statutory statute of limitations, it's a hard rule unless both sides agree to pause the statute of limitations. Okay? Oh yeah, I got them. They're buried, but I got them. Oh yes, yes. The time stopped. Yes, yes. I am moody tonight. Look how moody I am. All right. So here we go. Why would anyone agree to the tolling agreement? Well, that's a good question, and something that Judge Engeron had brought up. He brought it up in his order, and he said the reason why was because the defendants didn't want to go forward with the lawsuit because the lawsuit was going forward because they were running out of time. So they said, hey, if you drop the lawsuit, this suit right here, that's why I'm pointing to it. If you drop this lawsuit, we will pause the statute of limitations with an agreement. So both sides entered into this agreement. The government would stop going forward and said, get your stuff in order, and then we'll talk again. And then, so they didn't have the lawsuit against them. Meanwhile, if the government found that they wanted to pursue it later on, they wouldn't be kept from doing that because the statute ran. So both sides had a benefit. Trump's side, they pulled the suit against them, and then the government side, they paused the statute of limitations so they didn't run out of time to file a suit. Yes, it was in the middle of his presidency. Yes. Yes, there was just a lot that was going on, and it was a huge benefit to them in order to have it paused so the suit didn't go forward at that particular time. At the time it needed to go forward in order for the statute of limitations to not run. So it was mutually agreed upon. Yes, he thought he could delay again. Yes, I think that's a good way of putting it. What was the date they signed the contract? Well, if I had the contract in my hand, I could show you, but for some reason, with my stack of thousands of sheets of paper, I can't find it. But I believe it was August. Actually, let's just take a look. All right, I can't abide by that. Let me show you here on the exhibits list. All right, so just a minute. Correspondence, affirmation, email, proposed order. Loan agreement. Here we go. Here's the tolling agreement. All right. Here we go. The tolling agreement was dated August 27th of 2021. That's when it was dated. All right. There was a draft of the tolling agreement. There was another draft up here, but it was dated August 27th of 2021. All right. And everybody had signed on to it. So this was during this whole, and again, it's just in here over and over and over again because it's so important. Okay. All right. So there you have it. I don't have the actual agreement, but found everything else except for the agreement. So the agreement is what spared Ivanka from all of this. So she is lucky. So whatever she was doing at that time that pulled her out of the business, it was a smart move. Yeah, I mean, there's 1,552. Oh, I think we added 3 more. Hold on. That's not true. I got to give you the exact number. 1,555. Yeah, there were a few orders that were added. So it's a lot. There's a lot. All right. So, yes, the tolling agreement. I will have to find it, everybody. I apologize. I was supposed to have it with me tonight, but I have somehow lost it in my massive stacks of paper, but I will make a post on that. Right. So let me finish up with Ivanka's situation. Again, we've got the state here trying to say Ivanka should be involved in the conspiracy. They set out their cases.
And then I'll just go into this very first introduction paragraph to give you this overview of what Ivanka's role was, so we have a better understanding of why she wasn't involved. Ivanka Trump's motion to dismiss should be denied. Her challenge to the complaint is exceedingly narrow. Ms. Trump does not challenge the allegations by the Office of the Attorney General showing the valuations of the statement of financial condition were false and misleading. She does not challenge the allegations in the complaint asserting those statements were material to loan totaling hundreds of millions of dollars. Nor does she challenge the allegations that the use of the false misleading statements saved the Trump Organization hundreds of millions of dollars in interest payments over the past decade. Instead, Ms. Trump argues that she was not sufficiently involved in the preparation of those statements to be liable. That even though she was an executive vice president responsible for obtaining hundreds of millions of dollars in loans from the Deutsche Bank, she is not liable if those loans were procured through fraud. Ms. Trump contends that she had no involvement in creating or disseminating the statements, that she never reviewed them, she never submitted them to anyone. Those claims are belied by the allegations in the complaint and the record before the court. So, those were her claims, and she did win on her appeal, and they did dismiss her out of the case. What the state goes on to do then throughout the rest of this is just to explain that she was involved. She was a part of this whole thing. She knew what was going on. She knew about the details of everything, going all the way back to December of 2011. So again, we've got receipts showing the calendar with her name included in it. We have her situation specifically of knowing that the fraud had occurred. So all of this is explained within the state's motion here. So again, I'm not going to read through every single page of it, but she does a pretty good job setting it out. Ultimately, the Court of Appeals decided to say she was not included in the tolling agreement and therefore was not part of it. So the statute did run for her, and that's why she was pulled out. So again, not because she didn't do it, but because the statute of limitations ran. Now, this piece I think is very important. Ivanka Trump and the other defendants concealed their fraud until February of 2019, right? So again, if you think about the presidency period of time, this was 2 years into the presidency, Ms. Trump acknowledges that the AG did not have notice of the fraud alleged in this action until February of 2019, when Trump's former attorney, Michael Cohen, testified before Congress. She then argues that the AG cannot invoke the discovery rule to extend the statute of limitations because it does not apply to the government enforcement agencies. But one does not need to look at discovery rule because the statute of limitations is told as to all defendants, including Ms. Trump, because they fraudulently concealed their wrongdoing. Now, again, that argument was not successful, but it just kind of went in to show that she felt that Ivanka should have been included in all of this. They lost that on appeal, but then next we have affirmation of Sharif Gaber in opposition to Ivanka Trump's motion to dismiss. So this is just a couple of pages here where we have supporting information again stating that Ivanka should be involved. So an attorney duly admitted to practice before the courts of the state does hereby state the following under penalty of perjury. I'm an assistant attorney general of the Office of the New York State Attorney General's Office who appears on behalf of the people. I submit this affirmation in support. Next we have, I'm familiar with the facts and circumstances set forth in this affirmation, which are based upon my personal knowledge. I've attached here to all exhibits, true and correct copies of the following documents excerpted where designated. Attached 1, Exhibit 1 is a true and correct copy of a document bearing production number, this, produced by the Trump Organization response to the subpoenas. The document is an email from Graf, the senior vice president, assistant to the president at the Trump Organization, forwarding a document entitled Ivanka Trump. So on he goes, listing multiple other pieces showing Ivanka's involvement in all of this. So I mean, it's pretty clear, but the appellate court found the other way. So Ivanka was out. She was pulled. So there you have it. So there's the piece about Ivanka and why she was out. Again, she was not part of the tolling agreement, which hopefully I will find. If you all could see my desk right now, this is a mess. This is such a mess. Now, I think also I've got another interesting visual aid that I found. I have two more documents I want to show you. One is a motion in limine, and another one is a motion to strike from the government. But another really interesting complaint, the document that the state put together that I thought would be very helpful. Let me bump my camera up here. What do you think about that case? You know, I can see what they're saying. I can see both sides of the argument. So, you know, from a criminal perspective, I would want everybody, all conspirators to be included. But honestly, I'm not advanced enough in my knowledge of real estate to know whether or not it would be appropriate. So honestly, I'm just not sure. But the state did prepare. I have to continue to think about it. They're my favorite to watch. Oh, that's so sweet. That's so sweet. What about Don Jr.? Yeah, I think they were all clearly involved at the date and time of the agreement. So now the state put together a color flow chart, which you know how I feel about color coding everything. Deceptive strategies defined. So for each different color, there's a different deceptive strategy. I thought this would be fascinating to go through. First, we have A, so including in the value of the partnership assets in which Mr. Trump has only a limited interest with no control over disposition, as if directly owned by him and under his control. B, again, these are the strategies used by the defendants. Valuing properties subject to legal restrictions that negatively impact value as if they could be sold free and clear of such restrictions. C, valuing unsold apartments and homes using the offering plan or asking prices rather than the current market value. So these are, again, the strategies used here by the defendants. D, valuing unsold apartments that are subject to a purchase option at a value far greater than the option price. E, using a figure for net operating income that assumes lower expenses and or higher income than what is reflected in the company's financial records. F, using low capitalization rates that are cherry-picked from generic marketing materials to derive the rate to use for variations while ignoring higher rates listed for properties in the same materials that are more comparable. I mean, that's huge. G, ignoring the impact of ground lease terms and valuing properties that are subject to ground lease. H, using sales of properties that are not comparable to inflate valuations. I, using an inflated square footage figure when valuing a property based on a price per square foot. J, failing to conduct a discounted cash flow analysis to derive the present value for anticipated future outcome. Oh my gosh, it was well thought out. Exactly, it really was. I mean, this sets out every single action here that was done that was fraudulent. Next, K, increasing the value of a property by a fixed percentage to account for Trump brand value, which, you know, that's no good. L, including income from speculative future deals labeled to be determined, despite representing only signed deals are included in the value. So it wasn't the fact that they said that there could be, oh, okay, we love that. Thank you, everybody. Thank you for that. So it wasn't the fact that they said necessarily that there could be profits. It's that they said when they signed the sheet that wasn't taken into consideration. So that's where the fraud was. It wasn't that they were saying this could be more. It was that they said they did not state it in the information they gave. All right. And M, using fixed assets approach to value a golf club rather than acceptable approaches using income or comparable sales. So the values they were using was incorrect. Did someone mention profits? Clarence Thomas. Justice Thomas, what are you doing here? N, inflating the purchase price of a golf club by including the amount of membership deposit liability, despite representing the liability was worth zero. So this was huge. They said they only had a zero liability when it actually was millions of dollars. So that was another big piece. O, valuing unsold golf memberships at inflated prices that conflicted with what was actually being charged. And P, including fees from related party transactions between Trump Organization affiliates as if they were transactions with outside entities negotiated at arm's length. All right, so this is a lot. These are all of the strategies that were the deceptive strategies used by the defendants. Now, this next chart is just my favorite thing ever. So this is where they went through. They set out the assets here, and then they set out the colored dot for which deceptive strategies were used. Right? Isn't that amazing? I know, right? I looked at this, I was like, what are you talking about? So let me go through this chart with you a little bit. Here we have the assets, here we have the years. Here's all of the deceptive strategies that were used. So for each one, they've set out which one of these wrongful acts were done. So let me just take you through what assets they've got here. First is cash, then they have escrow, Trump Park Avenue, 40 Wall Street, Nike Town, Trump Tower, Seven Springs, Trump Triplex, Vornado Partnership, Las Vegas, Mar-a-Lago, Trump Aberdeen, Trump Turnberry, Jupiter, Briarcliff, LA, Colts Neck, Philadelphia, DC, Charlotte, Hudson Valley, and licensing development fees. So for each one of these, for each year, they set out which deceptive strategies were used. Isn't that fantastic? Doing the Lord's work. Oh, thank you. Well, I mean, this AG is like, what? What are you doing? This is amazing. Yeah, this is really amazing. I thought the work that they put into this chart to make this, I mean, it couldn't be any clearer. All you need to do is take a look at any property. So let's just take a look at Mar-a-Lago, all right? And we'll look at the year 2011. So we have B and C, H and K. So first we look at B. We valued properties subject to legal restrictions that negatively impact the values as they could be sold free and clear of such restrictions. And C, valuing unsold apartments and homes using the offering plan and asking prices rather than the current market value. So there we have B and C. Now we have H and K. So also using sales of properties that are not comparable to inflate valuations. And then K is increasing the values of a property by a fixed percentage to account for Trump brand value. So those are all of the deceptive practices done in 2011 with respect to Mar-a-Lago. I know, Tara. Yeah. I mean, it's pretty amazing. Each and every single property is included, and then each and every year, and then which deceptive practices were done. So whomever put this together was genius, because it's just amazing how it's been set out. Now, you can find this online. This is available online. I've been trying to figure out how to get a video together to show you all how to find this, but I'm a little bit behind. I'm a little behind, but let me show you where it's at. If you go online, all right, I'll just talk you through it at the moment. If you go online and you look for the New York State Unified Court System, all right, you put that in. You put in Donald Trump as defendant, and then you look for the one that says people of the state of New York. Click on that, and then you click on e-file documents, and it'll bring this entire thing up, all right? Now, the one I'm looking at right now, this chart, you can find right here. It is exhibit set out here, and it's document number 3. So if you are interested in finding that, you can go again to the New York State Unified Court System, Donald Trump as defendant, people of the state of New York, pull up the e-file documents, And then you can get that document number 3. Yep. What the public has to understand is there's penalty and interest on all of these. Yes. Oh, very true. Very, very true. How many pages long is the form of all of this evidence? I'm not sure. Maybe 20 pages. I think 20 pages front back. We've got 1,555 different filings because we had 3 today and the notice of appeal that came out yesterday. So this is the opening statement from the defendants that I went through the other night, and then I've got the opening statement of the government right here. So these are the documents I've been going through right here. I'll make a lovely frame. Do Vegas. Okay, sure. Yeah. Let's take a look. All right, so here we go. Let's take a look at some of these other properties in here. We've got, all right, so here we have Vegas. Now it looks like J, is that J? Hold on, everybody. That's a J. It's a J. So it looks like J is on all of the Vegas ones, but I'll go back and get some more details here. Failing to conduct a discounted cash flow analysis to derive the present value for anticipated future outcome. Whoa, okay, so discounted cash flow analysis was not done for anticipated future income. And then we have C for 2017 and 2018. So let's take a look at that one. So in Las Vegas, they were valuing unsold apartments and homes using the offering plan or asking prices rather than the current market value. Whoa. All right, so that's not good. They did that for 2 years, 2017 and 2018. So that is Las Vegas. I think so. I think the states could potentially sue, but I mean, again, I'm not sure what the purpose would be, right? Because the reason why we sue is because there has been someone who has been harmed. Now, the state of New York, whatever, and so there needs to be some kind of damages that need to be given back to the harmed party. So that's what we would need to do. So if the party wouldn't be able to really gain back any damages, then they may not find it to be worth it. These markings are covered, reveals Ivana's real location. Yes, that's right, if we could feel them out. But yeah, I mean, there's really a lot. And if you look, like if I covered this up and showed everything just after he was elected president, I mean, there's so much. There are so many. Again, each dot represents a deceptive practice that is not allowed, that is not lawfully allowed. So every single property had pretty much almost multiple violations of deceptive strategies. Yes, Mar-a-Lago. Let's take a look at that. So I think that's interesting. I mean, here's before he was president, and then here is after he was president. So, I mean, it's quite a bit. So let's take a look at Mar-a-Lago. Let's go back into, let's start here in 2016. It looks like we've got B and H repeatedly. So this is, again, Mar-a-Lago. So B is valuing property subject to legal restrictions that negatively impact value as if they could be sold free and clear of such restrictions. So they had legal restrictions on them, but when they valued them, they pretended that they didn't so that they could get a better value for it. So that was number 1 for Mar-a-Lago. And then H, using sales of properties that are not comparable to inflate valuations. So improper property sales, the valuations that they used in there was another one. You know you messed up when someone color codes your BS. Oh my gosh, it's so true though. It's so true. I mean, it really is. So if I was to look, just looking at this chart, it looks like maybe Turnberry has the least amount on it. I mean, that's kind of what it looks like to me. So they just have M, and all of it started after he was president. So let's take a look at what M says. using a fixed assets approach to value a golf club rather than acceptable approaches using income or comparable sales. All right, so that was pretty significant. Valuing is a residential home when it isn't. I think so. Yeah, I think, and they're using the way that they're valuing it is not what is the standard way of doing it. Yep. I thought he got Turnberry after he was president. Did he? Maybe so. Maybe that's exactly then why there weren't any. I don't know. I have not kept up on that. But as you can see, 2011 to 2016, we don't have any for Turnberry. But meanwhile, for his other golf clubs, again, we have Aberdeen here, which is full on, and especially right when he became president, they had a lot going on. It looks like they pulled back in 2019, but there were a lot of things going on here. And then Jupiter looks pretty consistent. Briarcliff looks pretty consistent. LA also looks pretty consistent here. Philadelphia has a lot though. Wow, Philadelphia is packed. Let's take a look at Philadelphia. So we've got the golf course in Philadelphia, GKMN. So let's look at G. Ignoring the impact of ground lease terms in valuing properties that are not subject to a ground lease. Ooh, all right. Then we have K. Increasing the value of a property by a fixed percentage to account for Trump brand value. Boy, that K is really a stickler, isn't it? I bet K is in almost everything. Almost. And then M, we just went through, and then N, inflating the purchase price of a golf club by including the amount of membership deposit liability, despite representing the liability was worth 0. So this is where we had the membership issues. Distraught 500 million lawsuit against Cohen. Yes, I've heard that. I've not been able to pull up the details yet, but I'm really interested to see how that worked out because I knew there were going to be some problems. So yeah, I mean, that's pretty significant. So let's look here. We've got K is the brand value. So when the brand value was used is K. So we can see there's a lot of K's in here. I mean, there's a lot. Mar-a-Lago has K. Let's see what else. These do not. So we don't have K on, we don't have brand name for Park Avenue, Wall Street, Trump Tower. Why wouldn't Trump Tower use the brand name? It seems like brand would be used for Trump Tower. Let's look and see what he did use for Trump Tower. That's very interesting to me. E and F. So E, using a figure for net operating income that assumes lower expenses and or higher income than what is reflected in the company's financial records. Whoa. And then F, so we're on Trump Tower here, using low capitalization rates that are cherry-picked from generic marketing materials to derive the rate to use for valuations while ignoring higher rates listed for properties in the same materials that are more comparable. Right, so we've got, those seem to be the dominant factors for Trump Tower, and then Seven Springs, again, I'm looking for the ones that he used the brand value on. So Mar-a-Lago up until 2016, so up until then. And then Jupiter looks like LA, Colts Neck, Philadelphia. It looks like mostly his golf courses is where he used his brand value. So that seems to be the trend for that. So most of that was for his golf courses. Yes, New York Unified Court System website. And then you have to make sure that you put in Donald Trump as the defendant. And then you want to click on the e-file documents. All right. Again, I'm just trying to figure out how to make you all a post about it. But because when you click on it, they just pull up like 10 names. You got to go to the bottom and click on the e-file documents. But you can, you should be able to find it okay. It's not too hard to find once you get into it. You just got to make sure you look for a little box marked e-files. And then you can go in and you can take a look at all 1,555 documents. Allison Greenfield, who wrote that decision valuing at 18 million. Oh, interesting. Do something tomorrow from work. that you can use if you want. Oh, VC, that would be amazing if you've got time. If you've got time. I'm just, I'm kind of slow. My technology knowledge is limited. I do the best I can, but why is New York lowest court named the Supreme Court? You know what, Danny? That's really an excellent question. And it drives me bonkers because it absolutely drives me bonkers because in most states, of course, the Supreme Court is the top court. But in New York, I think it's just because it's tradition. That's how they originally set it up way, way, way back in the old days, and they just kept the name. So yeah, it's just kind of frustrating. They call it the Supreme Court, but meanwhile, it's not. It's the trial court. So, yeah. So I know it's very frustrating. But I do highly recommend taking a look at this document if you get a chance. Again, I will try to set something up to try to walk everybody through. I might need to just stop being so picky and just kind of do a quick and dirty version and how to find it rather than trying to make it, perfect, but at least something that's usable at least. So we'll see about that. Yes. All right. So I've got a couple more documents I wanted to share with everyone that I thought were really interesting. Here, we've had some discussion before about this motion in limine stuff, right? We've talked about motions in limine. So a motion in limine is a motion you file in order to keep certain evidence out of court. Now, it's interesting because this is a bench trial, so a judge has to decide if the motion in limine is going to be granted, but the judge is the only one seeing the evidence. So it's kind of a weird situation with a bench trial where they're saying, we want to keep this evidence out, but you have to see it in order to make that determination. So it's a little bit different how it's all set up. All right, so we've got defendant's memorandum of law in support of a motion in limine. So I wanted to just show you this to kind of give you an idea of the format of what it looks like. We would start with a preliminary statement because we're going to hear a lot about motions in limine over the next few weeks, so I think this is really important. The preliminary statement, the court should exclude from trial evidence that's inadmissible. They should exclude the examinations under oath of third-party witnesses taken by the plaintiff during the special proceeding as inadmissible hearsay. So there were witnesses whose testimony was taken down by the state, emotional lemonade. And so they're wanting those statements to be tossed. Defendants had no opportunity to cross-examine these witnesses, and the court should accordingly prevent the use of those statements. So when you're arguing a motion in limine, you're saying there's evidence that just should not be allowed. So they set out what they believe the law is, that the examinations that were under oath are hearsay because there was no cross-examination. Oh, hydrate, yes. Oh, I've forgotten. Oh dear, I should do that. I should. Thank you for reminding me. Yikes. Right. Whew. Okay, so then they just go on with their arguments here. So again, I'm just showing you this to give you an idea of what a motion in limine looks like. It's not particularly good. It's not a particularly good, well-written one, but I think it's a good example. So they go in again and just talk about, what evidence was discussed by these third-party witnesses, and they didn't get a chance to cross-examine them, so it shouldn't be allowed. Now, again, this is a bench trial, so the judge has already seen all of this evidence. So they're asking the judge to keep out evidence he's already seen. So, that's not necessarily the best strategy, but that's what they've chosen to do here. So that's a motion in limine. We also have, I thought this was fascinating too, where we have the state that filed a motion to strike the proposed testimony of Lawrence Moens. This was very interesting. So defendants have retained a Palm Beach real estate broker to offer purported expert testimony, right? We talked about the defendant's list of witnesses, and we had, what did we come up with, 15 experts? Something like that. Well, one of their experts is this guy, and they're saying The expert testimony concerning the value of his Palm Beach properties, including Mar-a-Lago. Contrary to all the evidence in the record, Mr. Moen claims that Mar-a-Lago was undervalued by the defendants in Mr. Trump's SFC, so his disclosed financial statement, and that Mr. Trump's South Florida membership club has been steadily rising in value from an estimated $655 million in 2011 to over $1 billion in 2021. But his estimates are based on almost no disclosed data and no verifiable methodology whatsoever. Mr. Moen's estimates are instead, by his own admission, based on the speculation and fantasy rather than the application of accepted valuation methods to facts about this property. So that's pretty harsh. Yes. So one of their expert witnesses, the government is saying, is completely not reliable, and that his methods for choosing how he came up with his numbers are not based in any acceptable form. I thought that was very interesting because that's a really good point. They're calling in all of these experts in order to testify. And I think we talked about this before. What happens when the experts start disagreeing with each other? Well, then it comes down to the credibility. And so they're trying to take this expert off of the table before it even starts because he's not credible. Basically, he's full of it. Yes. Yes. So again, this particular motion I thought was just really fascinating because it goes into this idea of credibility. So at his deposition, Mr. Moens made numerous admissions to show his opinions about the valuation of Mar-a-Lago and other properties to be speculative, contrary to the factual record, and therefore inadmissible. And again, we've heard press conferences over the last few days talking about how much Mar-a-Lago was worth. And even Trump's attorney had been on Fox right after the trial today talking about how the valuation was completely wrong. Now they're using this guy's analysis for their valuation. So here's a couple of examples on how he came up with the number. Mr. Moens admitted that his valuations were based on his gut feeling, that his report didn't list verifying information, and that it would not be possible for another person to reproduce his analysis. All right, so that's kind of a big deal. Next, Mr. Moens testified that his valuation of Mar-a-Lago did not depend on whether the property could be used as a private residence or only as a social club. So your methodology for valuation did not change depending on whether it was operated as a social club, as it currently is, or if it was converted to a private residence. Answer: well, again, you could maintain a private club and be a single member at that club. So I don't see any difference in value. But this opinion is plainly wrong on the facts, given evidence in the record showing that Mr. Trump restricted the use of the Mar-a-Lago, at least in part, to take advantage of the lower valuation and lower tax assessment that resulted from the annual appraisals conducted by the Palm Beach County Appraiser's Office. So that's a really huge, that's a huge issue. Yeah, gut feeling, exactly. So last time when we were talking about different witnesses, I had my rules of evidence were in my car. So I pulled them out tonight so I can show you real quick what we have when it comes to witnesses. We have certain rules that we have to follow. Now, when we have an expert witness pulled in, it says a witness who's qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if A, the expert's scientific, technical, or specialized knowledge will help the trier of fact to understand the evidence to determine a fact and issue. The testimony is based on sufficient facts or data. The testimony is a product of reliable principles and methods. And so all of these need to be, it's not an or. The and the ors are very important. And D, the expert has reliably applied the principles and methods to the facts of the case. So these are the rules for having an expert witness. So the government here is just saying that he is not reliable as an expert witness. Some pretty significant Trump-related news just broke. Oh, really? Really? Oh, no. What did I miss? Did I miss something? Oh, my gosh. Uh-oh. I'm always the last to know. My head's buried in the book of a rule of evidence. Oh my goodness. All right, hold on, everybody. Just let me check real quick. Can't keep me on the edge of my... Spill the tea. Yeah, the nuclear subs. Are you talking about the nuclear subs? Yeah. Yeah. Yeah, I was talking about that right at the very beginning. There had been okay. Yeah, let me explain. Yep. So, said Trump a lawsuit he was supposed to testify in? Yes. So what they're saying is there's a character limit. You're so funny. All right. So the news at the top of the hour was that there was a man from Australia who had been making conversation in Mar-a-Lago with Trump, and after he had left the White House. And part of that conversation was about submarines. And Trump had volunteered specific information about our nuclear submarines. And this man had gone back to Australia, talked to a couple of prime ministers, talked to several other people in his company, and had given this information out. Now, the Justice Department had started to do research and finally had said to this man, please stop saying this information out to other people. And so the man said, whoops, sorry. So he stopped. But yes, so that information just broke. Yep. Yeah, 45 people. Yep. Yeah, I mean, it was like an hour ago, so that's still pretty new. Oh, that's still pretty new. Yeah, I mean, that's pretty significant. And, I think it's really worth noting that a lot of the issues here aren't necessarily about that he just had these documents, but the issue, of the Florida case, but the issue is who has seen the documents now. Because we don't know. We don't know who from what countries have that kind of knowledge. So, yeah, that would be seen as treason. Yep. Yep. Yes, the MyPillow guy lawyers dropped him. Yes, they did. They most certainly did. They said, look, we want to get paid. He said, I'm not going to pay you. And they said, bye-bye. So that's how that went down. It was very interesting. Very interesting. Yes. So, all right. So that's really all I have for documents specifically that I wanted to go through with everyone tonight. So I wanted to kind of do a Q&A at this point of any questions that people have. And then also to give you an update on the trial calendar. So I'm digging through my papers right now to find my trial calendar. So one moment. As I dig through. I'm completely buried up to my neck in paperwork at the moment. Oh, I'm swimming in paperwork. Oh my goodness. All right. Let me see. Let me find my calendar here. I'll give that just a minute. Oh my gosh. Oh no, I'm gonna trip. Nope. Oh my gosh. All right, let me try this side over here. Oh my goodness. I feel like I'm never going to crawl out of my paperwork. Is it a threat to our country? Oh, absolutely. Absolutely. That's so true. Very, very, very true. Absolutely. All right. So here we go. Don't fall. I made it around the corner. If you guys could see this mess. Oh my God. I'll just give you a little glimpse. Let me give you a little glimpse here. What? What is that? It's a mess. All right. So here we go. We've got, this is the calendar coming up. We've got a lot of stuff going on. So I wanted to kind of share what's been going on. We have several things, in Georgia, actually, that just went on. We had Sidney Powell's motion to dismiss today. And that hearing was almost 2 hours, and the judge was really not having it. I was very impressed with his work today. I thought he did very well. So he kind of smacked that down and said, what are you talking about? So Powell's motion was denied, but there were some discovery questions. Discovery will continue on in the Georgia case. So Georgia is green. That's why I'm pointing here. to the discovery question. Now, they have demurs. So the demurs that are set in Georgia are claiming that the information in the indictment's incorrect, that it's bad information. So they're asking for a hearing in order to talk about how the RICO law applies and how the indictment itself is wrong. So one of them had wanted to call in witnesses to talk about the legislative history and the point behind the laws that were written, but the judge is like, we just don't have time for that. So he has denied, he's denied that, but they do want to have a hearing. So they'll be having a hearing on the demurs. The judge said, Judge McAfee said he was going to probably split it into 2 days. So we'll have 2 days of hearing on demurs in Georgia. So multiple people have joined in on that. So that'll be Monday and Tuesday, and then probably more discovery issues. But then we've only got the rest of that week, and then we are into the jury questionnaire pieces. So we're just 2 weeks out from the trial on the 23rd. It's a lot. There's a lot going on here. Now, if you remember, Cheesebro has 2 attorneys, right? Mr. Lemonade and then the other guy that's kind of like a doofus. We kind of talked about the fact that he keeps asking for all of this extra stuff. Well, in today's hearing, he said to the judge, well, I'm thinking I might do interlocutory appeals, meaning he wants to appeal some of the discovery decisions that the judge has already made in Georgia. Okay, are you following me? So he wants to appeal those decisions. The judge said it's 45 days if you file interlocutory appeal. And so he said, you guys requested speedy and we're going to have speedy. So he had to put his foot down with Cheesebro's attorney and be like, look, we're not moving the date of the trial. So I thought that that was pretty interesting. I thought he did a really good job. The judge did a great job on that. So that's kind of what's going on in Georgia right now. So we'll be prepping for that. Things are really going to really kick up a lot for Georgia very soon. Yeah, I thought the judge was amazing. Well, and the judge already has, Judge McAfee, he's got another jury trial right now. So he's like running into the courtroom and is like, okay, I've got like an hour because I got to go back to my jury trial. He's like, let's do this. Let's get it done. I was very impressed. Tolstergist. Oh my gosh, that's hilarious. All right. So that was Georgia. Now, this week we've really been involved a lot with the New York civil trial, but I probably will not be this extensive on the future updates on the New York case because at this point, I think we all realize now that we're just looking at documents and it's just a fight of, I guess what Trump's attorney had said when she went on today was she said everybody wants their day in court and we want to have our day in court. So I think, we all realize now this is really just a dog and pony show so that they can have their day in court. So I don't think anything very substantive is going to really come from the rest of this particular case. I mean, we'll keep an eye on it, but we're really starting to transition into a lot of stuff going on in Georgia and DC in this case. So we've got Georgia going on. Now, the next big thing that we have then in DC is we do have that motion that he did, a motion to dismiss for immunity. So what I've done is I put together a proposed live schedule of the things I want to talk about. So let me I haven't highlighted it yet, but this is how I'm predicting I'm going to try to do the next batch of lives, everybody. So to try to get some of these things in. So let me just take you through what my thoughts are. So far this week, we've been doing the civil trial review, civil trial again. So tonight we went through the government's opening statements and exhibits. So tomorrow, what I want to go through is that motion to dismiss that was filed in DC. So that'll be on a live tomorrow. That's not going to take that long. So I want to do that. But then I did want to do a live. I think you guys saw my video I posted on the Giuliani cases. So his case is only like 8 pages, and Hunter's case isn't very long either. So that shouldn't take very long. So I think I'll probably go through the DC motion to dismiss and then the Giuliani cases just to kind of take care of that. Then that takes us to Saturday, where we should have an update then on the Georgia discovery situation. Oh, you're amazing. Oh, you're so sweet. Oh, thanks. No, I had to get myself sorted out. I was like, what's happening in this crazy world? So next, we also have the Cohen deposition. I doubt we'll hear much about that, but he may be on the shows talking about that deposition later. So I'm kind of keeping an eye out on that. But I am planning to come back on Sunday and just kind of do a quick recap of everything. So then that takes us then to Monday of next week. Now I want to do one more civil trial review since we'll be going into that second week. But then on the 10th, everybody, hopefully you'll join me because I want to review the New York criminal case. So we haven't spent much time on the criminal case, but let me give you a little sneak peek of what I've been working on here, which is absolutely fascinating. So in my humble opinion, we have, this is the New York criminal case, okay? So to the left. There we go. Here's the New York the New York criminal case. This is the hush money case, 34 counts falsifying business records. Each one of these counts is a Class E felony. So it's significant. We've got intent, and then we've got falsifying business records in the first degree. So amazing. Thank you for your work. It's truly incredible. Oh, well, you're welcome. I'm glad other people find it interesting. Absolutely. Yes, this is the Stormy Daniels case. So we haven't spent much time on it before, but on Tuesday, the motion to dismiss has to be responded to by the government. So I thought it would be the best time for us to go through the New York criminal case. So I'll be doing that next week then on Tuesday. Wednesday, I've got stuff going on, but then on the 12th, I would like to do a Florida update. At this point, we should have the SIPA hearing set, so we should know more about that. So we could do a Florida update. And then Friday, I will probably just do an overall review. So we'll just do a review of what's happened, probably pretty short. Back again to Sunday, we'll catch up one more time, maybe 2 more times with the civil case, just to kind of keep an eye on everything. It won't be too big, but to kind of talk about that. Now, the 16th is that gag order hearing. We probably will, there's no cameras, but I think it'll be good to see if an order comes out at some point, or if she gives us some idea of when her order is going to come out. So we'll probably do a DC update then. Then we're already into Georgia with the jury trial. This is when they're going to start talking about the jury questionnaires and getting into the jury questions. So this will be key. We're really going to focus on Georgia at that point. I'll do another weekly review. I'm going to try to do those on Fridays, just kind of go through what's been going on. Then probably on that Saturday, we've got motions due in DC. They usually file them a couple of days ahead of time. So I'm predicting we'll have motions out on the 21st. And then we've got Georgia starting on the 23rd. And then we'll be into Georgia. So the 23rd through the 25th, I'm planning to just focus on Georgia. All right, that's really my goal, is to hit those. Yes. Well, you got to color code it, right? So it's tentative. Yes, he dropped the Cohen suit. Yes, and I'll probably do a review of that Cohen suit also. I want to take a look at that a little bit closer. But yeah, I think that's pretty significant. But it was a pretty good, there was a pretty good chance it was going to get dismissed. He had already lost his CNN case, and so there were a lot of similar issues. So I'm not too surprised. So this is kind of my plan, my tentative schedule, everybody, for the next few weeks to kind of tackle, because it's so much. There's just so much going on. So this is really what's going to work out best for my schedule. I will continue to probably do 6 o'clock again, except for Fridays. I do want to start doing Friday mornings. So I'll probably do a double on Friday. I'll probably do a morning, like an hour one, and then in the evening, probably a shorter one too. Rather than a longer stretch of a couple hours, I'll probably just do one in the morning and one in the evening on Fridays. So I'll have to really flesh that out as we go through it. But that's kind of my plan at this point. Would probably be to be live tomorrow at 10 a.m. To do my first live, and then tomorrow at 6 p.m. to do the second live, and then that way kind of split the content. It works better for my schedule that way. But this is my tentative schedule. So hopefully, yes, I'm going to I will probably be picking up over the weekends. I'll probably be here more frequently than I have been. And probably be a bit thinner actually during the week. So especially the Wednesday period of time, I've got stuff going on the Wednesdays. So you may want to look for me Fridays, Saturdays, and Sundays. And again, I've got a bigger table now because I needed a bigger table for all of the paperwork. So I'll be able to go through more things like that. So, oh, thank you, Desert Skies. Yes, I'm trying to be more organized. No, I didn't get a new table. No, but I needed to switch. So I had to move some things around. So that, now that I've been able to move things around a little bit, it should work out a lot better. But I think as far as the buffering goes and sound and angles and things, this will work a lot better, I think. Yes, Central Time. So what I'm going to try to do is I'm going to try to do 10 a.m.s on Fridays and 6 p.m. So I'm going to try to do 2 on Fridays. One will just be just a review of what's happened. And then the rest, again, I will probably just be doing my normal 6 p.m. time. Tonight was a little late, but my schedule over the next few weeks, I've been able to really hash out. So I had a good idea of what I'd be available to do. So 6 p.m. Most nights, but look for me over the weekends because that's really where I'm going to try to put a little extra time in a little bit. But tonight, yes. Oh, good. I'm so glad. Yeah, I was wondering names. I had kind of moved a few things around here, and when I moved my location, I thought maybe things might work a little bit better. So I'm so glad to hear that. Yes. Yes, Central Time. Oh, hydrate. Yes. Thank you for the reminder. Hydrating. So yeah, we've got a busy few weeks coming up, but luckily for me, my off TikTok schedule is actually pretty light. So things are kind of winding down for me outside of TikTok. So this is working out for me scheduling wise, just fine. Yes, I have to plan very carefully. Do you store your documents in your bathroom? No, I don't. You're not supposed to do that. You shouldn't put your documents in your bathroom. No, but I do have some bins. My partner in crime is not impressed with the bins. So he's recommended that we get, I think we're going to get a TikTok filing cabinet. That's what he said. Because he stubbed his toe on it yesterday on one of my bins, and he's like, I can't do this. So I think we're going to get a filing cabinet just for that. By the pool. That's funny. Yes. Oh, I will. Yes, he thinks it's so fun. He's having a lot of fun with it too, but except for the tripping part. He's not a big fan of that. But it's fine. It's fine. He'll be fine. He's fine. So, but this should work out pretty good, I think, for the next few weeks. I know I got to get the boxes. I know. Do I change my polish? Yes, I do. I really change my polish when just right before I go on, so it doesn't get chipped. And then honestly, I just take it off. And then I put oil and stuff on my nails. So I don't really have my nail polish on for too long, honestly. So yes, good night, Gray. Good night. So this, hopefully this will work for everybody, and I will keep you updated on what's going on here with the trials that are going on. So yeah, I think so. I mean, sometimes if I'm seeing other people, then I make sure to have them. But other than that, I just try to kind of take care of them. I don't mind. It's enjoyable. It's for me, it's like a little timeout for myself to sit and do my nails. So yes, you're welcome. Thank you. Thank you for coming. I appreciate it. Thank you. Thanks, V. I appreciate that. Hand modeling. Oh, I don't know. I don't know about that. Oh my goodness. I'm not so sure. I'm not sure. Truly appreciate it. Thank you. Oh, you're welcome. You're welcome. Yes. So I will go ahead, everybody, and kind of sign off for tonight. We've covered a lot of material, but I will be back again tomorrow. I'll be back on in the morning, planning 10 o'clock at Central Time. And then, yes, 100K. Oh, thank you, everybody. Oh, I appreciate it. I really do appreciate it. Oh, you're welcome. You're absolutely welcome. So I'll be on tomorrow morning and then back at 6 o'clock Central Time in the evening. So yes, good night. Hey, good night. Have a wonderful night to everyone but the trolls. Oh, that's funny. Oh my gosh. Yes, yes, yes. I will see you all tomorrow, hopefully in the evening or in the morning, whichever one you can stop by. So take care, everybody. As always, thank you for spending some time with me. If you've got questions, feel free to always leave a comment on any of my posts. Happy to do that. Happy to take any of those questions, except about the box. All right. No questions about the box. Okay. None of this. No box questions. Other than that, any other questions are fine. Yes. Take care, everybody. Take care. Have a wonderful night. Yes. No more boxes. Okay. Yes, have a great night, everyone. We'll see you tomorrow. I need a sign-off phrase. I know. My closing arguments, I usually say thank you. So I'll say thank you, everybody, and take care. Have a wonderful night. And I'll see you tomorrow morning.